Hello, this is Ron Climer again with session number 5 of the comments about the North Carolina real estate license law. Now, if you have not been with us for the first 4 sessions, I would urge you to do so, but we are reading the comments which are in this textbook. Now, you may have another textbook, and this textbook will be obsolete in about 6 months anyway. But I've noticed on the textbook pages that this is on page 626 in this textbook. But at the bottom of the page, there's page numbers for the comments. And I'm on page 13. I'm starting at the top of the second column, and I am just reading the comments. And I've already read a bunch of them. Brokers as party to a transaction. There is an inherent conflict of interest presented by a broker representing the very party against whom the broker, as an interested party, is negotiating. Paragraph O of Rule 104 prohibits a broker who is selling property in which the broker has an ownership interest from representing a buyer of the property, except for a broker who is selling commercial real estate as defined in Rule 1802 of this subchapter, in which the broker has less than 25% ownership interest, may represent a buyer of that property. If the buyer consents to the representation after full written disclosure of the broker's ownership interest. However, a firm listing a property owned by a broker affiliated with the firm may represent a buyer of that property so long as the individual broker representing that buyer does not have an ownership interest in the property, and the buyer consents to the representation after full disclosure. Rule P of Rule A104 prohibits a listing broker or firm from purchasing a property listed by that broker or firm unless they first disclose to the seller in writing that a potential conflict of interest exists and the seller may want to seek independent counsel. Prior to the listing broker entering into a purchase contract, the individual listing broker and firm must either terminate the listing agreement or transfer the listing to another broker in the firm. Prior to the firm entering into a purchase contract, the listing broker and firm must disclose to the seller in writing that the seller has the right to terminate the listing. The broker or firm must terminate the listing upon the request of the seller. Broker name and address. Rule A103. A broker must notify the commission in writing, may include online, within 10 days of each change of personal name, firm name, trade name, residence address, and firm address. If a broker intends to advertise in any manner using a firm name or assumed name, which does not set forth the surname of the broker must first register that firm name or assumed name with the county register of deeds office in each county in which the broker intends to engage in brokerage activity, and must also notify the commission of the use of such firm name or assumed name. For individuals in partnership, a name is assumed when it does not include the surname of the licensee. For a firm required to be registered with the Secretary of State, a name is assumed when it is different from the firm's legal name as registered with the Secretary of State. Note, most franchises operate under assumed names that must be registered with the Register of Deeds office in every county where they conduct brokerage activities. A licensee operating as a sole proprietorship, partnership, or business entity other than a corporation or limited liability company may not include in its name the name of an unlicensed person or a provisional broker. A broker who proposes to use a business name and includes the name of another active, inactive, or canceled broker must have the permission of that broker or his or her authorized representative. This rule provision is intended to prohibit a broker or firm from using without proper authorization the name of some other broker or former broker who is not currently associated with the broker or firm, such as a former associate or a deceased broker. Advertising. A licensee must have the proper authority to advertise. A broker may not advertise or display a for sale or for rent sign on the property without the written consent of the owner or the owner's authorized agent. A broker may not advertise any brokerage service for another without the consent of their broker in charge and without including in any advertisement the name of the broker or firm with whom the provisional broker is associated. The rule also prohibits any advertisement by a licensee that indicates an offer to sell, buy, exchange, rent, or lease real estate being made by the licensee's principal without the involvement of a broker, i.e., a blind ad. All advertising by a licensee must indicate that it is an advertisement of a broker or brokerage firm. Delivery of instruments. Delivery of documents. Among other things, this rule, which implements, requires agents to immediately, but in no event later than 5 days from the date of execution, delivery to the parties thereto copies of any required written agency agreement, contract, offer, lease, or option affecting real property. Regarding offers, this does not mean the agent may in every case wait up to 5 days to present an offer to a seller. Rather, it means that an agent must immediately, as soon as possible, present to the seller any offer received by the agent. If the agent is the selling agent, then the offer should be immediately presented to the listing agent, who should in turn immediately present the offer to the seller. The 5-day provision is included only allow for situations where the seller is not immediately available, i.g., seller is out of town, represents an outside time limit within which offers must always be presented. In all cases where the seller is available, the offer should be presented as soon as possible. The same rule also means that a prospective buyer who signs an offer must immediately be provided a copy of such offer. A photocopy is acceptable for this purpose. Do not wait until the offer is accepted or rejected by the seller. In addition, this rule means that the offer must be immediately presented to the seller, even if there is a contract pending on the property. Of course, in this instance, it's essential that the agent also advise the seller that serious legal problems could result from the seller's acceptance of such offer, and that the seller should contact an attorney if he is interested in treating the offer as a backup offer or in attempt to be released from the previously signed contract. Copies of any signed sales contract or lease must also be promptly delivered to the parties within the 5-day period. Client should be provided a copy of the agency agreement upon signing, and both parties presumably are present, but certainly within 5 days of execution. Finally, GS 93 requires a broker to provide his or her client a detailed and accurate closing statement showing the receipt and disbursement of all monies relating to the transaction about which the broker knows or reasonably should know. Retention of records. Brokers are required to retain records pertaining to their brokerage transactions for 3 years from the successful or unsuccessful conclusion of the transaction, or to the disbursement of all trust monies pertaining to the transaction, whichever occurs later. However, if the broker's agency agreement is terminated prior to the conclusion of the transaction, the broker shall retain transaction records for 3 years after the agency agreement is terminated, or the disbursement of all funds held or paid by the broker in connection with the transaction, whichever occurs later. Documents that must be retained include sales contract, leases, offers, even those not accepted, agency contracts, earnest money receipts, trust account records, disclosure documents, closing statements, broker cooperation agreements, broker price opinions, comparative market analysis, including notes and supporting documentation, and other records relating to a transaction. Brokerage fees and compensation. This rule addresses various issues associated with the disclosure of and the sharing of compensation received by a real estate licensee. Disclosure of principal and compensation from a vendor of supplies or goods and services. Paragraph A prohibits a licensee from receiving any form of valuable consideration from a vendor or supplier of goods or services in connection with the expenditure made on behalf of the licensee's principal in a real estate transaction without first obtaining the written consent of the principal. Example: a broker manages several renting units for various owners and routinely employs Ajax cleaning service to clean the units after the tenants leave. The broker pays Ajax $50 per unit fee for his services out of rental proceeds received and deposited in the trust account. Ajax then refunds to the broker $10 for each $50 fee it receives, but the property owner is not aware of that the broker receives this payment from Ajax in addition to the regular brokerage fee. The broker in this situation is making a secret profit without the property owner's knowledge and is violating the commission rule. Disclosure to a party of compensation for recommending, procuring, or arranging services for the party. Paragraph B prohibits a licensee from receiving any form of valuable consideration for recommending, procuring, or arranging services for a party to a real estate transaction without full and timely disclosure to such party. The party for whom the services are recommended, procured, or arranged does not have to be the agent's principal. Example, an agent sells a listed lot to a buyer who wants to build a house. Without the buyer's knowledge, the agent arranges with ABC Home Builders for ABC to pay the agent a 3% referral fee if the agent recommends ABC to the buyer and the buyer employs ABC to build his house. The agent then recommends ABC to the buyer. ABC builds the buyer's house for $100,000, and ABC secretly pays the agent $3,000 for his referral of the buyer. The agent has violated this rule. Note that the buyer in this situation likely paid $3,000 more for his house than was necessary because it is very likely the builder added the agent's referral fee to the price he charged the buyer for building the house. The main point here is the buyer had the right to know that the agent was providing disinterested advice when recommending, that the agent was not providing disinterested advice when recommending the builder. Example, a selling agent in a real estate transaction, while acting as a sub-agent of the seller, recommends to a buyer who has submitted an offer that the buyer apply to Ready Cash Mortgage Company for his mortgage loan. The agent knows that Ready Cash will pay him a referral fee of $100 for sending him the buyer's business if the loan is made to the buyer, but the agent does not disclose this fact to the buyer. If the agent subsequently accepts the referral fee from the lender, he will have violated this rule. The buyer has the right to know that the agent's recommendation is not a disinterested one. Disclosure to principle of compensation for brokerage services in sales transactions. Paragraph C deals with disclosure to a licensed principal of the licensee's compensation in a sales transaction from various sources other than in situations addressed in paragraph A and B. A broker may not receive any compensation, incentive, bonus, rebate, or other consideration of more than a nominal value from his or her principal unless the compensation is provided for in a written agency contract or from any other party or person unless the broker provides his or her principal a full and timely disclosure of the compensation. Example, ABC Home Builders offers to pay any broker who procures a buyer for one of ABC's inventory homes a bonus of $1,000 in addition to any brokerage commission the broker earns under any agency contract and for commission split agreement. Any broker working with a broker client who is considering the purchase of one of ABC's homes must comply with the disclosure requirements and disclose the bonus to the buyer in a timely manner. If ABC Home Builders also offers a bonus of $2,000 on a second sale of one of its homes and $3,000 on a third sale, if the buyer's broker has already sold one of ABC's homes, then the broker must disclose to his or her buyer principal the entire bonus program and that his or her bonus will be at least $2,000 if the buyer purchases an ABC home. Nominal compensation. Compensation is to be considered nominal if it is insignificant, token, or merely symbolic worth. The commission has gifts of $25 bottle of wine or a $50 gift certificate as being examples of nominal compensation paid to a broker that do not require the consent of the broker's principal. Full and timely disclosure. Paragraph D of Rule 109 explains what is meant by full and timely disclosure. In paragraph A, B, and C, full disclosure includes a description of the compensation, incentive, including its value and identity of the person or party by whom it will be paid. The disclosure is timely when it's made in sufficient time to aid a reasonable person's decision making. In a sales transaction, disclosure will be made orally, but must be confirmed in writing before the principal makes and accepts an offer to buy or sell. Restrictions on compensation disclosure requirements. Paragraph C clarifies that a broker does not have to disclose to a person who is not his or her principal the compensation the broker expects to receive from his or her principal, and further clarifies that a broker does not have to disclose to his principal the compensation the broker expects to receive from the broker's employing broker firm, i.e. the individual share of the compensation paid to the broker's employing firm. North Carolina Real Estate Commission will not arbitrate commission disputes. 63A provides that the commission shall not make rules or regulations regulating commissions, salaries, or fees to be charged by a licensee. Paragraph F of Rule 109 augments that statutory provision by providing that the commission will not act as a board of arbitration regarding such matters as the rate of commission, the division of commissions, rate of broker, and similar matters. Compensation of unlicensed persons by brokers prohibited. GS 93 authorizes the commission to take disciplinary action against a licensee for paying any person for acts performed in violation of the license law. Paragraph G simply augments this statutory provision by providing an affirmative statement that a licensee shall not in any manner compensate or share compensation with unlicensed persons or entities for acts performed in North Carolina for which a license is required. Note that a North Carolina broker may split commissions or pay referrals fees to licensees from another state so long as that out-of-state licensee does not provide any brokerage service while physically in the state of North Carolina. One narrow, limited exception to this restriction is provided in paragraph H. Licensees may pay referral fees to travel agents who contact them to book vacation rentals only so long as well-defined procedures are followed. RESPA prohibitions control. Finally, paragraph I of Rule 109 provides that nothing in this rule permits a licensee to accept any fee, kickback, etc. that's prohibited by the Federal Real Estate Settlement Procedures Act, RESPA, or implementing rules, or to fail to make any disclosure required by that act or rule. And that's a good place for me to take another break, and we'll come back in a few minutes. But